Yeah. Yes.
Okay. You see if it says anything.
The streaming is on, and the courtroom is ready. All rise.
Mr. Romsey.
Just before we turn to anomalies, there are a couple of points I ought to make about the 1933 Act. If one turns, please, behind divider 2 in the first authorities bundle. I wanted to just draw attention to the fact that it's more detailed in its content and structure than the 1920 Act.
I seem to have a copy of the report.
Yes, that seems to.
Well, it should all have been replaced in your hard copy bundle. I'd understood that replacements had been sent.
I don't quite know.
Certainly that was noticed towards the end of last week, and replacement pages were sent. Can I just tell your lordships what the points I make are, and we'll that needs to be corrected now this afternoon, so we get the relevant.
So there wasn't originally the 1933 Act wasn't in tab 2. Is that right? I mean, it should have been, but
it should have been. It wasn't. There was a mistake in the copy.
And you sent something. You sent them by email, did you? Or?
No, and hard copies, I think, to the court.
Anyway,
but anyway, look, we'll get that sorted out
anyway.
absolutely as soon as we can.
All right. So,
can I just tell you the points I wish to make?
Yeah.
It's much more detailed, and there's a good deal more to it than there is in the 1920 Act. The basic provision, again, it's a registration process. The basic provision, the basic structure is that it provides for the recognition of conventions by orders in council. Subsection 1(2) then provides that a judgment of a recognised court is within this subsection if it satisfies the following conditions, namely, and it explicitly says it is either final and conclusive as between the judgment debtor and the judgment creditor requires the former to make an interim payment, payable under it a sum of money, it is given after the coming into force of the order in council. So that in the way that the 1920 Act doesn't do is more explicit as to what is covered. And then it now has, since 1982, the exclusion for judgments on judgments. And then in paragraph, in section 4, there are first detailed provisions which require the court, no discretion, require the court to set aside the registration if, and then there's a number of the common law principles relied on. The judgment is not a judgment to which that part of the Act applies, but then the courts of the country of the original court had no jurisdiction, but the judgment debtor being defendant in the proceedings in the original court did not receive notice, and so on and so forth. It's a standard list of compulsory exclusions from the scope of registration. And then, but it goes further in subparagraph 4(2), because it then goes on to provide that for the purposes of this section, the courts of the country of the original court shall, subject to provisions of subsection 3, be deemed to have had jurisdiction. And then there's a series, if you like, of counterpart provisions that begin, if the judgment debtor being a defendant in the original court submitted to the jurisdiction. And then little 3, if the judgment debtor being a defendant in the original court had, before the commencement of the proceedings, agreed in respect of the subject matter of the proceedings to submit to the jurisdiction of that court or of the courts of the country of that court, and so on. There's a series, again, reflecting the common law principles by which a party may become bound by a judgment. And then, but there's then an exclusionary provision, which may be of some significance in section 4.3, notwithstanding anything in subsection 2 of this section, the courts of the country of the original court shall not be deemed to have had jurisdiction. And then there are 2 provisions that are of relevance, one of which has been repealed, but it was there in 1933. The first is A, if the subject matter of the proceedings was immovable property outside the country of the original court. And that sounds to us as if it can only be talking about the substance of what I've called the original judgment. And then B has in fact now been repealed, but it was there in 1933, and one can find the text of it by looking at Patchett, which is behind divider 24, and turning to paragraph 227, 2.27. The latter part of 2.27 at page 56.
This is divider 24.
Divider 24, it's an extract from the book from Patchett's book on enforcement of foreign judgment.
So page?
Page 56.
Again, I don't know what... We haven't got these elsewhere, have we? I haven't got...
This came in late as well. Oh dear, I'm so sorry.
I thought I had these, actually. I don't know where they are. There's somewhere else we've got Patchett or not. Patchett.
Well, it will have come in separately.
Have you got these?
Yes, I think this came in to me with no instructions where to put it, so I simply put it at the back of the existing.
Can I?
Well, maybe they are there. Let me have another look.
It's page 56 of the Patchett book.
Sorry, no. Oh, I haven't got it.
Which has got something called Article 8 on it.
Not paragraph 2.27.
I think something did come in, but I haven't got it. Anyway, Patchett, page, what is it?
56.
Okay.
Top left-hand corner.
You carry
Well,
on.
I'll tell your lordship the point.
Yeah.
This contains, halfway down page 56, the repealed provision of the 1933 Act, which was there originally, and it says, dealing with the cases in which the original court cannot be deemed to have had jurisdiction, except in the cases mentioned in subparagraphs 1, 2 and 3 of paragraph A and in paragraph C above, if the bringing of the proceedings in the original court was contrary to an agreement under which the dispute in question was to be settled, otherwise than by proceedings in the court of the country of that court. And that is, on the face of it, a reference to some form of exclusive jurisdiction provision, which can only be of significance and importance in the present context if the original court is the true original court, as we say it is. Then finally, there are 3 anomalies.
But there's nothing, is this right, that if you succeed in avoiding all the exceptions and you are within the Act, then there is no discretion.
No discretion.
And therefore, to the extent that the discretion is, as it were, doing a lot of work in the 1920 Act, it's not there to do that equivalent work in the 1933 Act.
No, there is one discretionary element if one looks at under section 4.1, there's the series A 1 to 6, which requires that the registration of the judgment shall be set aside if the courts of the etc. had no jurisdiction. But there is some discretion, may be set aside, but this is applicable in only limited circumstances, may be set aside if the registering court is satisfied that the matter in dispute in the proceedings in the original court had previously to the date of the judgment in the original court been the subject of a final and conclusive judgment by a court having jurisdiction in the matter.
Yes.
So there's a restricted scope for restricted discretion in a particular circumstance. But that's it so far as discretion in the 1933 Act is concerned.
Yes.
So then, as I said before the short adjournment, I wanted just to draw your lordships' and ladyships' attention to what we say are three anomalies on the respondent's construction. I've dealt with one and I've said it a number of times. The consequence of their construction is that the 1920 Act only requires scrutiny for compliance with the various conditions that are set on the intermediate judgment, not on the original judgment. And that, in the context of this regime as a whole, makes, we submit, little sense. And as I said, I think at the outset, more than that, it may also be said that the common law and the principle that the foreign judgment is to be taken to be final and conclusive on its merits, it in fact excludes scrutiny of the judgment of the real original court, precisely because, and this is Mr. Reza's case, because the merits of the intermediate court judgment do themselves involve, or should involve, consideration of the treatment of the original judgment in the intermediate court. So that's the first anomaly, and I've made that point a number of times. The second is that under 9.1 of the Act, the time limit for registration is 12 months. So 9.1 provides, where a judgment is to be obtained in a superior court, etc., the judgment creditor may apply to the High Court in England or to the Court of Session in Scotland at any time within 12 months after the date of the judgment. And of course, what Mr. Reza's construction involves is the potential, at any rate, to drag that out over a number of years and potentially over a large number of judgments. On his case, as I understand it, you can take your Cayman Island judgment to another reciprocating jurisdiction and then bring it to the English jurisdiction, and so on and so forth. At each stage, obtaining either a registration or a judgment on the underlying, a judgment on the judgment itself at common law. So that's thoroughly anomalous. There's a time limit in section 9.1, which on Mr. Reza's case, his client can avoid. And the third point is this. Again, we submit this is anomalous. That the practice of judgment trafficking, or forum shopping, as it's referred to in the Owens and Bracco judgment, is generally recognised to be undesirable and itself anomalous. But Mr. Reza's case involves a submission that Parliament itself must have authorised or sanctioned that practice, both under the 1920 Act and, for that matter, under the 1933 Act, notwithstanding that, at any rate so far as the 1933 Act was concerned, it was using, to some extent, the European exequatur as a model, and at the same time being concerned to ensure that there was reciprocity. And we submit, has to be The reality is, so it appears to us, that neither in 1933 nor in 1920 did it occur to anybody framing or passing this act that judgments on judgments might be included. But to the extent that it's said that they are and not excluded by the 1920 Act, it does involve the submission that Parliament has itself authorised or sanctioned what seems to be generally recognised to be an undesirable practice.
But just to explain that, why is it undesirable?
Well, it is generally because there's an element of secularity here. It's because it avoids or evades the steps that are, as a matter of common law, generally
I see.
the steps and principles that are regarded as essential to assessment at common law of whether a judgment can be enforced here.
Yes,
So,
I see. Yes.
absence of jurisdiction and so on and so forth.
Yes.
Well, I've overrun my time a little bit.
Thank you. Well, thank you very much, Mr. Onslow. Yes, Mr. Reza.
Lords, my lady, subject to the order in which it might be most helpful, my oral submissions, will be fourfold. Submission 1, which will be my principal submission, is that the court is concerned with the construction of this statute, and what the common law was before 1920 or now is of little relevance or assistance. And what I say, and I'll come back to it in more detail when I develop it, the relevant statutory regime and the express words are clear, and the judge was right to find, after correctly construing the Act, that she was entitled to register the claim in judgment. And your Lordship's already seen, my learned friend took you very quickly to section 9.5. The common law action based on a prior judgment was not abolished. There was a cost consequence if you chose that route. And that construction, in my submission, doesn't result in absurd results or unintended parliamentary consequences. Before I go on to let me just tell your Lordships what the second submission will be this. If the common law is relevant, then I say the Cayman judgment and the respondents complied with the common law tests and requirements, such as they were. My third submission, which is split into two parts, is if we get into purposive construction of the statutory scheme under the 1920 Act, with regard to the common law position, I say Parliament never intended, either in 1920 or in 1982, to exclude judgment upon a judgment in the sense my learned friend describes it, judgment laundering, forum shopping. And it could have done, it didn't do so. And the second part of that third submission is that exclusion of judgment upon a judgment in learned friend's sense, and I was going to say the non-merger rule, but no, I don't think the learned friends relying on that anymore, are the types of fundamental change requiring specific amending legislation. And my last submission, if your Lordships want to hear it, is that in the circumstances of this case, the consent order is an additional and separate path to uphold the main judgment. Now, my Lord, before I deal with that, I was going to deal with some introductory matters, but my Lord, may I just make one thing? The learned friend invited your Lordships, my lady, to have regard to what happened in the 1933 Act and the amendments to it, and also to have regard to the civil law position and what was envisaged under the original Brussels Convention, now recast, in aiding your construction of the 1920 Act. And may I invite your Lordships not to follow him down that path? And I say so on fairly mundane reasons. If I could ask you, your Lordships, just to pick up the learned friend's replacement skeleton and go to tab 2 and go to page 21. Your Lordship sees that it is the learned friend's skeleton. His name appears at the end of it, although he adopted, I think, learned friend predecessors. If your Lordship goes to paragraph 23, your Lordship sees there is no English authority deciding the point of relation to it. The learned judge was taken to a Scottish decision. In fact, my learned friend below took the judge to the decision. The decision was Veniscandia. and also took her to the Hong Kong decision, Morgan Stanley, which Your Lordship sees at tab 23. And then, Lord, the important words, however, the learned judge rightly concluded that the terms of the 1920 Act are to be read on their own, and that reading is not informed by the 82 Amendment to the 1933 Act. And I would respectfully say that is correct, but in any event, there's no appeal against that finding, which is, I think, finding 87 in the judgment. If you let it, Lordship's note and the lady, it's the note I'll come back to, because I'm going to touch on that in due course. And I say, when you come to construction, you look at the Act primarily. The fact that there are different statutory regimes and different regimes in common law and civil law jurisdictions doesn't assist your lordships. So, Lord, may I just deal with the introductory remarks? I want to just deal with this so that we can go on with it very quickly. My learned friend's argument that you have to have regard to the substantive merits and the original courts have to adjudicate on those merits is made on behalf of an evasive judgment debtor with a very, very long history of avoiding enforcement. And your lordships will have seen from the judgment there were 6 jurisdictions: the United Kingdom, United States of America, Belgium, Cayman, France and Italy. And that's at paragraph 114 of the judgment. And your lordships will recall that's at page 110, tab 9. And that history, it starts at the bottom of page 110.
And these may be powerful forensic points, but do they help us on the meaning
Well,
of the Act?
Lord, I just deal with the reason for this is simply this. My learned friend says this is a case of forum shopping, judgment trafficking, and Lord, of course, it's an interesting argument, but in this case, what actually happened, as part of the background, on 2 occasions, this debtor told, for example, the Singapore court, I'm ready, willing and able to go to arbitration, and then...
Mr. Reza, my lord has indicated we're not sure how this is going to help, but as the learned judge recorded, no reason has been given as to why your client didn't take advantage of the original registration of the Singapore judgment. I'm not inviting an explanation, but it perhaps illustrates why we are here concerned with an issue of law.
Yeah. Well, my lord, may I just... it was going to go on to this point. I was just going to address it before I come to my 4 oral submissions. This, the answer to my learned friend's complaints about judgment on a judgment in the sense he's advanced it and judgment trafficking is that the reality of this case, the judge could have not registered the judgment if she had found, in the circumstances, it was an abuse. And the reason I mention that is because on 2 occasions, the appellant expressly invited the judge and submitted that the Cayman judgment was not enforced because it would have been abuse. And just for your lordship's note to recall that, she undertook that exercise at the invitation of the appellant, and she found on 2 occasions it wasn't an abuse. And my lord, they are, could I just give them the pen without coming back to it, in connection with the judgment, that's at paragraph 115 Roman 2G, that's page 112 of the court judgment. Paragraph 124, that's page 114, and paragraph 128. So she expressly found it wasn't an abuse on the alternative grounds. And when it came to the question of writ of control, of course, enforcement proper against property in this jurisdiction, again, paragraph 139 and 142 Roman 3, she expressly found it wasn't an abuse. And Lord, I say that my learned friend's complaints about judgment trafficking, the absence of control of service, which is what of concern, and the automatic provision of registration are met, I would say, if we need to get there, correctly by the judge by looking to see whether or not, in the circumstance of an individual case, it's an abuse. Lord, could I just take your lordship very briefly, and it will be brief, to my chronology, and I explain to your lordships why it's relevant to the issues which have been advanced. Tab 6 of the core bundle. And Lord, it's a depressingly long document, and most of it is of no relevance today at all. And if your lordship sees page 51, this was the form of the chronology before the judge, and the parts in red are just what have been amended before your lordships and my lady, and we don't have to look at the 8 volumes and all the page references have been taken out. Wherever there's a red amendment, it's because what's before your lordships. And could I just say, because it came in Learned Friends a note that the complaint about we trying to bypass limitation provisions, when of course your lordships will recall, the judge found we brought the proceedings in Cayman because we wanted to enforce against assets we thought were there. If your lordships go to page 55, at the bottom of page 55, your lordships will see 19th October 2006. That's when the Wang fund, the $48 million as it later became, was discovered to be in Cayman, which the appellant was laying claim to, ultimately unsuccessfully in the Wang proceedings. By that stage, we'd already sought to enforce in 3 different jurisdictions. So that was the fund that was there. If your lordships then go to page 56, we start off a few years later when we discover the existence of that fund in Cayman, and the first affidavit of John Smith, which is set out, Lord, I don't think we need to take it out, except it was relied on, in fact, in Learned Friends in the Wang proceedings, which sets out the history of the final Singapore judgment. B, your lordship see that we had already started to enforce in Belgium, for example, we couldn't successfully, and going all the way down to the bottom of H, we experienced difficulty enforcing the judgment, various investigations of possible assets, and we believe there were some in this jurisdiction. And that was the basis of the Cayman proceedings themselves. If your lordship go to page 57, the 4th block down, your lordship sees 27th February 2009. We'd issued proceedings by then, we hadn't served them, and they were amended on the 27th of February to plead the re judicata estoppel, which eventually, when Mr. Justice Quinn, before judgment was entered in Cayman, knew that because he was taken to the amended writ. And a lordship C, paragraph 3b, is not in because the argument came in late, pleaded the final Singapore judgment operated as a re judicata estoppel between the parties. And then service, there's no dispute the matters were served. We then get very close to the default judgment, my lord, my lady, page 58, after all the matters were, if you see, on the 24th of June 2009, there was the affidavit of Lisa Ann Wellman, relied on support of the entry of the default judgment, relying on Grant and Easton, a case of the implied contract, new cause of action, and by that stage, we'd attempted to enforce in France now, United States, Belgium, United Kingdom, which was part of it covered in the affidavit evidence. And can I just, and I'll take your lordship to very, very few documents.
Mr. Fraser, I'm getting a little lost. I'm sorry. Why are you taking us to this?
It's on the basis of the common law action. If I have to say the common law was relevant, it's as to what basis was the judgment, the Cayman judgment, how was it categorised in common law, how was it categorised in Cayman? And the only point is this. I say that under the doctrine of obligation, which was the common law principle on which we relied in Cayman, we were entitled to enter the judgment.
Yeah, but the aspect of the common law, I think, with which we're concerned, is whether at common law you can obtain a judgment in the English court on a foreign judgment.
That's right. That's precisely
I don't
the
think
point.
we need all this for that,
Well,
do we?
If your lordship looks at the bottom of page 58 of the chronology, and I'll take your lordship to the one judgment. These were the outlined submissions before Mr. Justice Quinn. Your lordship sees on the 25th of June. And that appears, one of the few documents we need to look at, tab 21 of the supplemental bundle, page 119. Your lordship has that. This was counsel appeared on behalf of the plaintiff, and Mr. Key will write at the end, page 123, and these were the submissions before Mr. Justice Quinn, before he entered judgment later that day. And your lordship see paragraph 1, first of all, the amended writ, so that's the re judicata argument. relies on it. Paragraph 2 is advanced on the basis of the unsatisfied monetary obligation owing under the Singapore judgment. The plaintiff is not suing on the original cause of action. This follows from the accepted doctrine of obligation cast upon the defendant to pay the debt due. And your Lordship sees the reference to Rule 34. For your Lordship's note, that now is Rule 41, the modern Rule 41. But there was a specific reference to Dicey on the basis on which we were entering judgment and were suing. I think, your Lordship, friends already said, that sort of judgment can be impeached on limited grounds. No res judicata, fraud, public policy, and breach of natural justice. If we go over to page 120, paragraph 9, there's the new cause of action, headed, an action on a foreign judgment is an action in debt. There's the principle relied on there. Your Lordship sees the famous judgment of Master of Rolls in Granted Eastwood, paragraph 9.4. Those are the verbatim words which Lord Justice Bowen and Lord Justice Bagley agreed with. So there's the basis of the action on an action in debt, a separate obligation. And then the English authorities start at the bottom of page 10, Mr. Justice Buckley and V. Flynn. Your Lordship sees over the page in 10.2 that Mr. Justice Buckley made it clear that where a judgment is obtained in a foreign court, the cause of action does not merge in the judgment. Thereafter, the successful party can either relitigate his original cause of action in this jurisdiction, or he can bring an action in this jurisdiction upon the foreign judgment. On those being, as I understand it, two distinct causes of action. So, my Lord, that was the basis addressed. That was our cause of action under the law of obligation. One then sees other matters, English case of Mr. Justice Blair, paragraph 12 in NML Capital against Republic of Argentina, and this was after the 1934 Act of Law. And then, my Lord, the guts of it, which answers many of the submissions my learned friends making. If your Lordship goes to the top of page 122, the judge was addressed on the requirements before a default judgment could be entered into payment. And each element, re judicata, and of course the important matter, decision of competent court, for debt, final conclusive. And that starts at paragraph 13, and your Lordships, my lady, see that the reference to Rule 35, which is the new Rule 42, which your Lordships were taken to this morning, and the various elements all set out there, we've seen them before, final conclusive, for a debt, and so on and so forth. And all those authorities, you've been taken to Dicey at Authority 20, and on that basis, on which the judge was addressed, and on the basis of that aspect of English common law, followed the common law in Cayman, judgment was entered. And thereafter, I don't think I need to take your trouble up with the chronology. The rest of it, your Lordship sees the default judgment, which is at the bottom of the page, bottom page 59. It's 25th June, and it's referred to by ladyship below. The recitals are all set out there in detail, and then we go on, and eventually we get to, if your Lordship sees the bottom of page 60, the only other document which I think I want to take your Lordships to, 23rd of October, defendant's submissions for adjournment. That's tab 26 of the supplement bundle, page 137. And what happened here, which was touched on, of course, by the judge below, by this stage we had served the defendant, we had served, no dispute about that, and we had also applied for a charging order. And we served the defendant's previous solicitors, and on the 23rd of October, the present solicitors, or lawyers acting for the defendant, who eventually agreed the consent order, this was the point, made an application to Mr. Justice Quinn to adjourn. And your Lordship sees at paragraph 1, it comes before the re-amended charging order application. Paragraph 2 is a conflict of interest because the previous attorneys, I think they were Conyers, said there was a conflict. And then paragraph 3, Diamond Jones were retained by the defendants to act in this cause. and we weren't going to agree in a German, I understand. Your Lordship goes over the page, and this is the critical paragraph is paragraph 6. In order to properly consider its position, take advice on the issues raised, the defendant craves in the German plaintiff's application for reasons including the funds, that they were the WAN funds, it's B, which is the parts I rely on. There is extreme prejudice to the defendant if the charging order in ISI is made absolute, where the defendant has not had an opportunity to take legal advice and consider its options regarding any evidence in reply or cross-applications it may be entitled to make. And the German was successful, but of course, any applications, as my Lord Justice Richards quite rightly pointed out, included applications to set aside the Cayman default judgment, to go back to Singapore, to make whatever appropriate steps it could to challenge the Cayman judgment. And the Lord, it didn't, of course, and 19 months later, on the chronology, as your Lordship can see, it goes to page 62. Page 62, on the 16th of May, the consent order was agreed, and Lordship, I've set out the pages reference, I don't need to turn it up. Your Lordships know the judge below relied on that, I think in 15 different places in the judgment, to say why, in the circumstance of this case, the registration of that judgment was not going to be set aside. With that introduction, may I just go on to my first submission? My first submission is that your Lordships, my lady, are concerned with the construction of a statute on its own terms, not to be informed by what other legislative regimes and the civil law jurisdictions or the Brussels Convention dealt with a particular problem. Your Lordships will see that we say we entered this judgment on the doctrine of obligation as ventilated, in fact, originally by Lord Justice Lindley in Nuvia, which I may touch on very briefly. But whatever the basis of it, I say that the common law on this construction argument has a very minor role. It may even be irrelevant, because the relevant statutory scheme and the words are clear. The judge below said you can't escape from the words any judgment on whereby a sum of money is made payable. And that, my submission, was correct, and that construction is not absurd. Now, Lord, can we just look at the Act very quickly again, and to make my points on how one goes about construing this statute? Unfortunately, part 1 of the Act was not photocopied for your Lordships. It's actually in my original replacement skeleton what the legislative scheme of the Act envisaged. My Lord, if I just read you from the policy of the preamble to part 1 of the Act, which is not before your Lordships, it is an Act, my Lord, to make provision for the enforcement in the United Kingdom of judgments given in foreign countries which accord reciprocal treatment to judgments given in the United Kingdom for facilitating the enforcement of foreign countries of judgments given in the United Kingdom and for other matters aforesaid. And Lord Justice Richards was right. The scheme of the Act is between friendly, reciprocating dominions who we trust. And my Lord, if I could use the expression reciprocating territories to discuss the effects of this Act and one other Canadian decision, which I will take your Lordships to, my submission is that if Cayman was not a reciprocating territory subject to the Act couldn't apply. I would accept that. Put another way, the Act can only apply between the United Kingdom, Cayman and Singapore because they were reciprocating territories, but not otherwise. Your Lordships may know, conveniently, because it will come on to one Privy Council case which I'll take. I don't know if your Lordships have the practice next to you, but the territories are helpfully set out by the editors, volume 1, page 2255. And your Lordships will see that by orders in council, the friendly, trusted, reciprocating territories are specified. And Lordship sees it's 74.63. Lordship sees the list of countries there. Antigua and Barbuda is a reciprocating territory, which I'll come to because that will be the subject matter of a submission. And your Lordships also see that Singapore and Cayman are in there. Cayman Islands about 8 lines down, Singapore over the page. Australia and British Columbia, as it is, are not, and Hong Kong no longer became. So, my Lord, looking at section 1 of the Act itself, we haven't got section 9 and section 12. In my submission, the combined effect of section 9 and 12 and the statutory scheme as touched on in section 14 as well, which is the extensions to part 2 of the Act, which deal with where reciprocal provisions apply, is that a court in this jurisdiction may register any judgment or order attained by a superior court of a reciprocating dominion, my words, reciprocating territory subject to the Act. And, Lord, one sees that the Act itself only applies to reciprocating territories. Much of my learned friend's argument about jurisdiction, supervision and so forth goes out, my Lord, because when your Lordship goes to section 12, your Lordship sees that the court has obviously got to be a court of reciprocating territory. That's part of the definition of section 12. And we see it's quite specific. It's an order from in a sense, and it's got to be by a court in that territory. And once you've got that, you can enforce it. Lord, my learned friend touched on the question of original court. It's a very interesting debate as to whether original court means Singapore, or it means Cayman, or it means something else. In my submission, and this is for the it clearly means Cayman. And Lord, we'll see how another Court of Appeal in British Columbia construed words very similar to original court, a similar conclusion. But the reason why I think it must be Cayman, the only place where the expression original court appears, and I may be wrong on this, is 9.2a. If your Lordship go back to section 9.2, your Lordship sees the exception set out after the courts exercise its discretion on all the circumstances, whether it's just and convenient. Subsection 2, listing the exceptions, make it clear that no judgment shall be ordered to be registered under this section if, A, the original court acted without jurisdiction. And the expression original court nowhere else appears in part 2. And so
it appears in paragraph B.
And C.
My Lord, yes. My Lord, we approached it below that the original court, after some doubt, must be applying to Cayman, because the Cayman will see whether or not it exercises its jurisdiction, in part looking at whether or not the Singapore court went wrong, and so on and so forth. But what I say on the statutory scheme, irrespective, in fact, whether or not one answers the question, does original court mean Cayman or not, the definition is quite interesting because it's not quite the same in Canada. If your Lordship goes back to section 12, your Lordship sees the expression judgment means any judgment or order given or made by a court in any civil proceedings. Now, I suppose that could either be the original court or it could be any court. I mean, what I say is it says any court, and if your Lordships construe it to mean Cayman, your Lordship I still succeed on this. It's still a judgment within the terms of section 12. Now, my Lord, could I, before I take your Lordship to authority, just make this point? The judge was correct to focus on construing the Act. She's in good company as to how one comes to the answer whether or not this is a judgment capable of registration in Great Britain. Before one goes to the other statutory matters, she has to take on board for her discretion. And what I will say is, in fact, that the drift of the authorities has been since 1992 to look just at the legislative language rather than focus on the common law position before the Act was passed. And I think if we have to go back and then do a purposive construction, I'll go to that. But on this part of the law, may I now start with, first of all, with Owens Bank, which is in Authorities Bundle 6. And it's the first case where it seems that you focus on the statute to provide the answers to whether or not this judgment was capable of registration. In Lordship, the head note I don't think is of terrible importance. Saying the learned was right, there was an argument about whether or not which civil law, common law doctrine applied, and ultimately their lordships actually found that the statutory construction gave the answer to which common law can apply. Lord, if your lordship goes to page 443 first of all, we've got, that's the head note, and there's no parts I want to rely on. 487, Lord, is the first part. 487. E, and Lordship sees the speech of Lord Bridge from letter E, and it was submitted in that case that 9.2d must be construed as qualified by the common law rule that the unsuccessful party being sued to judgment is not permitted to challenge judgment on the ground obtained by fraud unless you could prove that fraud by fresh evidence. And that was the argument. That the normal English fraud exception with new evidence apply, or did the fraud as described in the Act apply? And that's what the lordships were entitled to look at. And Lord, from letter H, this is the starting point of Lord Bridge's speech. I do not find it necessary to examine these authorities. The rule they establish is unquestionable, and the principle on which they rest is clear. The question at issue in this appeal is whether a defendant is seeking to resist enforcement against him of a foreign judgment, either by an action on a foreign judgment or common law under the statutory mission.
I'm sorry, so we're on page 487, are we?
487, 483, my lord.
483.
483.
Sorry. And we're at letter...
Letter E.
Letter E, thank you. Yes, I see, sorry.
And Lord, it's from letter E on to C over the page. And then describing the common law position
I see.
of a court of competent jurisdiction at letter B. Lord, could I go to 487 E, my lord? And then the argument starts at D. The decisions that were being criticised were the two common law rules the appellant was unsuccessfully seeking to overturn. And the argument starts at D, goes on, Mr. Mann of the bank submits, time has come to overrule this. But then, my lord, it's letter E. I appreciate the force of this submission, and if the issue were governed only by the common law, I would think it necessary to examine in detail both the relevant authorities, Appellant, Oppenheim, and the argument skillfully deployed. But that is not the position. As I pointed out, enforcement in the United Kingdom of the judgments caused in the Commonwealth is governed by Section 9 of the Act, which is directly an issue. And then, my lord, it goes on to say, raising, of course, it's a question of construction at letter G, whether or not fraud in the case applied meant civil fraud or fraud under the Act. And then, my lord, after 487, if I could just very briefly take the lordships to 489F, which is the approach finally adopted by their lordships. My lord, it's letter D at page 489D. In the decisions of Appellant and Oppenheimer and Videla and Laws, the common law court declined to accord the same finality to foreign judgment, preferred to give primacy to the principle of fraud unravels everything. Then the old Judgment Extension Act is referred to, and then the argument of us whether or not how one construes the Act. My lord, letter F, and this is my point before I go on to another authority. I recognise the matter of policy there may be a very strong case to be made in the 1990s in favour, according to overseas judgment, same finalities. But enforcement of overseas judgment is now primarily governed by the statutory codes of 1920 and, of course, the 1933 Act. Since these cannot be altered except by further legislation, it seems to be out of question to alter the common law rule, and to do so would produce the absurd result that an overseas judgment creditor denies statutory enforcement on the ground if James' judgment by fraud concealed on a common law action, and so on and so forth. And he goes on to make the point that this whole field is effectively governed by statute, And if the rule now is in need of reform, legislature, not the judiciary, to deal with it. Lord, the next case
Isn't this simply saying that you've got, on the one hand, a rule about fraud as applied to English judgments, and on the other, you've got a rule about fraud as applied to foreign judgments, and in construing the Act, we will follow the common law rule which applies to foreign judgments.
Well, Lord, I'd say that was the start, but one focuses on the wording of the Act, and at the end of the day, whether or not one comes to construe the Act to adopt a different common law solution was one that the Lordships declined. The Lordship's right, that's one way of looking at judgment, but the starting point was that you look at the 1920 statutory regime and the 1933 regimes, and that was taken up, Lord, in Rubin, if I could take the Lordships to that, and that is page 16 of the Authorities Bundle. And Lord, Lordships obviously will appreciate that Owen was in fact addressed their Lordships. That appears at page 239 towards the bottom. So they had in mind the provisions of the 1920 Act, although they were dealing with the 1933 Act in this case. And my Lord, we go to 200 and I think paragraph 9 is the starting point, which I want to rely on. And paragraph 9, page 251. And Lordship sees that, paragraph 9, Lord Collins, after setting out what is Rule 43, no question of, said the theoretical basis for the enforcement of foreign judgments, common law, is the enforcement principle that where a court of competent jurisdiction has adjudicated a certain sum to be due from one person, a legal obligation arises to pay them, and that's the doctrinal obligation. And then the common law cases are all set out there. Adams, Cape Industry, Owen, Bank and Brasco. And then going on, as Blackburn said in Goddard Graves, was based on the mode of pleading an action on a foreign judgment of debt, not merely as evidence of the obligation to pay. But this is purely theoretical, an historical basis for the enforcement of foreign judgment to common law. It does not apply to enforcement under statute. And while I don't think there's any part of paragraph 10 I need to rely on, I wonder if I could just go to, for this part of the argument, to paragraph 127. And that is at the bottom of page 276.
Yes.
Mine, we seem to stop, mine at any rate, I think my lord, my lady, seems to stop at paragraph 39. Is yours? Yes.
Well,
so anyway, you better tell us what
if I
paragraphs
could
we
just
should read.
take these
Paragraph,
parts.
sorry?
It's paragraph 127, 128 and 129 to be read together.
Right.
And it's the same point again. It's that there's a discussion on how recognition applies to enforcement of foreign judgments of common law.
Right.
And how the English courts typically apply that. But, my Lord, it's the final part of paragraph 128. Lord Collins says, and if I read these words out, typically today, the introduction of new rules for enforcement of judgments depends on a degree of reciprocity. And it gives the example of the EC insolvency legislation and model law. A change in the settled law of the recognition and enforcement of judgments, in particular the formulation of a rule for the identification of those courts, which are to be regarded as courts of competent jurisdiction, such as the country with its insolvent entity that has its centre of interest and so forth, has all the hallmarks of legislation and is a matter for the legislature and not for judicial innovation. And then, my Lord, jumping a sentence, he recites Lord Bridges' comments in Owen. As Lord Bridge of Harwich put it in relation to a proposed change in the common law relating to fraud as a defence, the enforcement of foreign judgment, if the law is now in need of reform, it is the legislature, not the judiciary, to effect it. Lord, could Dicey, comments on Dicey may or may not help the Lordship. Parts of the Lordship's already been taken to, but I think, may I take the Lordships to, first of all, the Privy Council case, which is slightly out of sequence, and then to a decision of the Canadian Court of Appeal in British Columbia. If I could take you to Yearwood first of all, my lord. It's tab 18. I hope that's got your lordships.
Tab 18, is it?
Tab 18 on your
Yes, I've got Yearwood.
And Lord, this is a judgment which was reported 3 weeks ago,
Yes.
and it was reported after I put in my note, but it's in support of the points I made in paragraph 7 and 9 of my notes. So the common law doesn't help very much.
This is
And
paragraph 15, is it?
But
Aegis
my lord,
Acts.
before we look at the various parts of the judgment, may I just say this, because the learned friend refers to it in paragraph 15 and says you can't place much reliance on this. But, my lord, on page 1 of the judgment, your lordship sees who was in the Privy Council, and Lady Black gave the judgment, but it was a unanimous decision of all 5 members. And, my lord, may I just respectfully make this point? All of the judges sitting would have been aware of the rules of construction of statutes which would apply and the correct approach to them. That's my first submission on that. And also, my lord, it's fanciful to suppose that they wouldn't have been aware of the importance of this judgment to other reciprocating territories, in this case, as lordship sees, Antigua and Barbuda. And, Lord, can I just start off? The relevant part for my purposes, very quickly, because I think this is the basis on which the Privy Council came to this decision on this matrimonial case, is that the money judgments and the cost judgments in this case, unlike ordinary orders in matrimonial proceedings, were after the divorce, and they were money judgments. And so, to that extent, there was a familiarity as in the judgment in this case. It was a money judgment, and that's discussed in paragraph 4 of the judgment to say, for example, it's after the divorce, at certain times there were earlier judgments, and your lordship sees in paragraph 4 that the order they were mainly focusing on, 4 lines, and this order will be referred to hereafter as the money judgment order, and that was the one for 1.18 million rather than the earlier sum. And there's the cost judgment I don't need to take up. If your lordship then goes to paragraph 7, your lordship sees the issues that were concerned, and the issue, of course, is subparagraph 3 over the page, which is, are the orders outside the scope of the Act, which has echoes, of course, the learned friend's argument, are the judgments outside the provision of the Act itself. And of course, whether they qualify as a judgment, as defined by section 2.1 of the Act. And 2.1 of the Act, Lord, is in paragraph 8, and it's worth looking at because the wording is identical, as one would expect in the reciprocal legislative scheme. If your lordship looks at 2.1, judgment means any judgment or order given or made by a court in any civil proceeding, whereby, before passing of the Act, whereby any sum of money is made payable, and then your lordship sees that. So they were, in fact, approaching a very similar exercise to a ladyship below. On construing section 12, they construed section 2. And my lord, if one then goes to paragraph 11, they set out the order which they wanted to hear argue or deal with the issues, and then we get to paragraph 15. Lord, I'm sorry to take it a roundabout way. And this is the point which I rely on, and I say, respectfully, this is the correct approach. The husband's second argument is that the orders for the division of property and periodic payments are outside the Act in any event. He submits that to be registrable as a judgment, the judgment has to be final, and a financial remedy order such as that made in wife's favour does not satisfy that requirement. He relies upon the House of Lords case of Nuvian in support of this proposition. That case decided, lordships have seen that already. So, my lord, can we go on to 4 lines? As explained in oral submissions, this lack of finality derives from 2 particular elements of the order. Paragraph 2 of the order, which requires lump sum provisions for adjustment, I think for default provisions, and variation of trust. And we're going on to the guts of it, paragraph 15. It's submitted that these provisions provide for a continual adjustment of the sum due, reducing it by July 2000 to a sum which the present proceeding is concerned. Secondly, it's submitted that the December 2000 order did not extinguish the cause of action between the parties because by paragraph 8 it's provided that the wife's claims under the Matrimonial Causes Act were not extinguished. And so, Lord, may I just say, so they had a sort of statutory non-merger argument which was rejected. And, my lord, that's rejected for your lordship's note at paragraph 24, but it's not the heart of it. The heart of this judgment is paragraph 18. The board agrees that each of the 2 orders that the wife sought to register for enforcement constitutes a judgment as defined in section 2.1. It does not consider it can derive much assistance in determining what was intended to come within the definition of the term judgment in the Act from older common law cases such as Novian and Freeman. This is particularly so when the board, which the board is concerned, is an order making proceeding under the Matrimonial Codicil Act, which is a specialised statutory scheme. Jumping a line, the board therefore focuses on the words of the definition in section 2.1. As they're provided, what is required is that there is a judgment or order in civil proceedings whereby a sum of money is made payable. And well, that's my case, and that was the case which I respectfully say that her ladyship was correct in construing. One focuses on the Act, the wording of the Act is clear, there is a judgment whereby a sum of money is payable, and subject to that, subject to all the other statutory criteria which under the statutory scheme the judge is required to have regard to, it is enforceable. And the Lordship said that Novian and Freeman wasn't of much help on them. Your Lordship knows that's on certainty, on res judicata and so forth. But, my Lord, may I say, I apologise, I can't find a better record of this judgment as to what was before their Lordship, what cases they considered. Well, obviously they considered the Antiguan wording, which is identical to that in the 1920 Act. But, Lord, I think, having listened to the argument, which is recorded, of course, it looks like they had Owen and Bracco, because there was a reference to that, so that, unsurprisingly, that was before their lordships as well. Lord Legate and Lady Black certainly asked a number of questions, as did Lord Briggs, in terms of the approach and construction and so forth. But Lord, I don't think I can go much further than that, say what's in the judgment, except that this is an important judgment. It reconfirms the approach of Lord Bridge, in Lord Collins, I say, Lord as well, and we've now got to Lady Black giving the judgment of the Privy Council in Yearwood, Lord Carr, Black, Griggs, Sales, and they all agreeing. You focus, in my submission correctly, on the wording of the Act. The common law doesn't help very much on this statutory scheme for reciprocal enforcement. Lord, may I just, leaving Yearwood, go to one other authority which may be of some assistance as to how a different Court of Appeal has approached a similar problem. Would your Lordship go to tab 15 to Owen and Rocket Info? And look, Lord, before I take your Lordships to the facts and the principle in this case, may I just point out, in terms of a short way of dealing with all the editorial and academic comment, this case has not been commented on by Professor Patchett, or Professor Briggs. I don't think the only person who picked it up was in fact Dicey in a footnote to Rule 48 as an example of where a judgment creditor may have to take a number of steps to enforce his judgment. But there's very little help, but subject to that, my Lord. Your Lordship sees it's another decision of the British Court of Appeal of British Columbia. And my Lord, so far as it helps at all, of course, Canada, we all know from geography, is a number of provinces and territories, independent governments, separate legal systems in some cases, and a reciprocal enforcement obligation is important. And that's, of course, to that extent, it may or may not help your Lordships. Your Lordship sees from the head note that what happened here was there was a consulting agreement whereby the appellant agrees to provide services to an operating officer, and the laws of Nevada, United States, were to govern the agreement. The company subsequently terminated employment and he commenced an action in Nevada. So that's action 1. He was granted default judgment against that company in an amount of $46,000 odd. So that's judgment number 1, Lord, which he then entered as a sister state judgment in California. So that's judgment 2, crudely, Lord. Your Lordship will see in more greater detail how it's approached. The appellant commenced proceedings in British Columbia seeking registration, this is attempt number 3, of the Californian judgment. the Chamber's judge dismissed the petition. He found that registration of the judgment in British Columbia would defeat the intention of the Court Order Act, which I'll take lordships in a moment, so there's some similar wording. He found that the use of the words original court in Rule 52 meant that the appellant was not able to satisfy the requirements of the rule because the original court was Nevada, a non-reciprocating jurisdiction. There was the appeal of the Lord. California was a reciprocating state in Section 29 of the Act, and then the Lordship sees, pursuant to Section 28, the judgment was a judgment order of a court in civil proceedings if money was made payable. The Nevada judgment was money payable by the company to the appellant. The California judgment did not make money payable, but rather made the Nevada judgment enforceable in California, and so forth. And then, my Lord, we go on to part of the holding. The term judgment did not register or entered on the basis that granted by a court of another jurisdiction pursuant to legislation for the reciprocal enforcement of judgments. There was no originating process in California, law, that there was no opportunity for a defence to have been entered in the California process, as there was in Nevada. It would be possible to bring an action on the Nevada judgment, but not on the California judgment. So, a discussion on trafficking, if you like, and also in terms of reciprocal enforcement. And then, my Lord, before we go on, to allow the appellant's judgment to be registered in British Columbia would have had the effect of permitting the registration of a judgment granted by a court in non-reciprocating jurisdiction, contrary to Section 29 and 37 of the Act. The legislature did not intend to provide registration in British Columbia of a judgment granted by the court of another jurisdiction by an indirect method when it was not permitted to be done directly. Otherwise, when a state was declared to be a reciprocating state, it would have the effect of declaring all reciprocating judgments that jurisdiction also states of British Columbia for the purpose of registering judgment. So, my Lord, so they talked in terms of the vice, if you like, of judgment trafficking and reciprocation. My Lord, Your Lordship will see how it may help. Your Lordship, if we can just go to paragraph 1, and there's the decision given on behalf of the Court of Appeal by Appeal Judge Tyso, and Your Lordship sees the issue raised on this appeal is whether a judgment obtained in Nevada, entered as a sister state judgment in California, may be registered in British Columbia under the reciprocal enforcement provisions of Part 2 of the Court Enforcement Act. Lord, maybe just look at that very quickly. If Your Lordship keep your thumb on that page and go to page 379 of the judgment, Your Lordship sees the Act is appended to the judgment helpfully. And Your Lordship sees at page 379, the appendix, that familiar words to section 12, section 28 of the Canadian Act, judgment means a judgment or order of a court in civil proceedings if money is made payable, and then includes an arbitration award. And then I don't think I need to rely on any other part of that. If Your Lordship then goes to original court, it's defined in this Act, unlike the section 12, in relation to a judgment means the court that gave the judgment. And then section 29 of the Act, if a judgment has been given a court in a reciprocating state, the judgment creditor may apply to have the judgment registered in the Supreme Court unless, and there's various exceptions that I don't need to trouble Your Lordships with. It's familiar, some provisions of the 1933 Act, some of the 1920 Act, but I don't think I need to, the only part I need to take Your Lordships to is section 37, which is on page 382, and it extends reciprocating jurisdictions, which was the heart of this decision. Paragraph 37(1), if the Lieutenant General and Council is satisfied reciprocal provisions will be made by a state in or outside Canada, the enforcement of judgments given in British Columbia, and so forth, may declare a state to be a reciprocating state, and the common law action on an action in section 38 is not abolished. So that was what they were considering, very similar to section 12, the scheme, but not identical, but some help possibly on what original court means. If Your Lordship then goes to paragraph 5 of the judgment, which is page 373, Your Lordship sees, as I said on the facts, paragraph 5, the first default judgment in Nevada, and then attempts to enforce in paragraph 6, and then we get to the end, final words of paragraph 6, judgment ultimately entered in British Columbia, which is a reciprocating jurisdiction to California. So in January 2008, it's paragraph 7, the appellant commenced proceeding in the British Columbia Supreme Court seeking registration, and then Your Lordship sees 4 lines in reasons for judgment, the Chamber's judge held in British Columbia could defeat the intention of the court order and enforcement act and use the word original court meant that the appellant was not able to satisfy the requirements of Rule 54 because the original court was Nevada, a non-reciprocating jurisdiction. If your lordship goes to paragraph 9, before we go over the page, in my opinion, the issue at hand is resolved by the interpretation of Part 2 of the Act, and we've seen, I've taken the lordship's to that already. If your lordship goes to paragraph 11 over the page, California was declared to be a reciprocating state for the purposes of Part 2 pursuant to Section 37. Your lordship sees the only other states which have been declared to be reciprocating states are Washington, Alaska, Oregon, Colorado, and Idaho, but not, of course, Nevada, or, in the learned friend's case, Illinois, of course, which was the other issue. Two of the purposes of Part 2 are contained in Section 29 and Section 37. Section 39 contains the express purpose of making uniform the law of provinces that enact provisions equivalent to Part 2, but that purpose is not germane to this matter. Your lordship then goes to paragraph 13. Section 29 provides for the registration of a judgment in the British Columbia Supreme Court if it has been given in a court in a reciprocating state. The definition of the word judgment in Section 28 is a judgment or order of a court in a civil proceeding if money is made payable. In my opinion, it is the Nevada judgment that made money payable by the respondent to the appellant. The California judgment did not make money payable, but rather it made the Nevada judgment enforceable in California. And then we can jump after the quote which you all should see. Although an enter-sister state judgment is to have the same effect, that's in California, as an original money judgment, and may be enforced like one, it is not an original money judgment, and it is not the judgment by which the money becomes payable. And then, my lord, the point is made again in paragraph 15. The definition of Section 28 is original court in relation to a judgment, means the court that gave the judgment. In the face of this definition, I do not think anything we take from the word original. In my opinion, it is meant to convey nothing more than it is the court that gave the judgment that the holder is seeking to register in the British Columbia Court. Lord, paragraph 16 is very important, and I rely on it. This interpretation of the term original court is consistent with the decision of Gersberger and Krentz, which, Lord, I don't have, but what the relevant parts of it are made clear. In that case, the applicant obtained a judgment in Illinois, so judgment 1 in Illinois, sued on that judgment in Ontario, so that's the common law action in court number 2, and obtained a judgment in Ontario. So he's got a judgment, if you like, on the intermediate court. The applicant registered the Ontario judgment in Manitoba under the Act, which corresponds to Part 2 of the Court Enforcement Act. In refusing to set aside the registration of the Ontario judgment, Mr. Justice Dewars in Manitoba, paragraph 21, that the original court would not be the Illinois court because it is the Ontario judgment and not the Illinois judgment sought to be registered. So your lordship sees in paragraph 16 an example of a judgment upon a judgment, which of course is registered and enforced under the statutory regime for reciprocating territories. And the Lord, looking at that judgment, one sees that it has all the hallmarks, not quite all of them, as in this case, provided it's a reciprocating territory, Cayman, United Kingdom, and if it's relevant at all, Singapore. So there's no question of bypassing a jurisdiction without service. Then construing the words of the statute means that the judgment is registrable. One doesn't. The Canadian Supreme Court of Appeal are obviously concerned about judgment trafficking. We've seen an example of that. But, Lord, in my submission, adopting the approach in paragraph 16 is the correct one. And again, in company with the ladyship below and Lord Briggs, Lord at the Privy Council, that is the main focus on the answer to whether or not the judgment of the Cayman Court is registrable. Lord, just so we can finish it off, I don't think there's anything else in this judgment which helps. Paragraph 17 just stresses the term original court is important, and they make it clear it's important because original court means the court that gave the judgment, and so on and so forth. And
paragraph 17 is the critical paragraph, isn't it? Because it says the question is whether the type of judgment given by California or Cayman Islands is the type of judgment contemplated by Part 2. Yes. So you say this case supports you on the meaning of original court,
yes,
and that the decisive question is you look at the Cayman Islands judgment and see whether that is a judgment which says pay money,
Yes, right.
or whether it merely says you can enforce the Singapore judgment.
Of course. Well, I would accept that. And that's what I'm trying to say. That in answer to my own friend's question about what does original court mean, I think it must mean Cayman. And it looks like that is the approach. But whether or not one construes Section 12 to include original court may not matter. You look at the type of judgment that Cayman gave. Is it the type of judgment that's envisaged to be enforced under Section 12? Yes, I take it's a money judgment. And the law, that's reinforced by the other statutory exercises that the judge has to go through. Jurisdiction, which is not in dispute now, the fact that there was nothing that troubled the court in terms of all the circumstances and so on and so forth. And in my submission, the answer is that the judge is correct to say this is a judgment. Whether it's...
Does the Cayman Island judgment make money payable, or does it merely recognise that money is payable
it's a judgment.
in Singapore?
It's a judgment. A freezing injunction was obtained on it. And I think the wording of it, in answer to the law's point, if we can... Well, it's page 124. Lord, I think it's a judgment that makes it payable because of the opening paragraph 1 of or is that page 124, tab 22, my lord. So your lordship sees that the recitals said what the court had regard to. Your lordship knows that there were submissions on the basis of the judgment itself. And Lord, I just think the action is over, paragraph 1. The defendant do pay the sum of $1.573 million. And then the question of interest, and the law, I think paragraph 6 and 7 just deal with costs in this action, the freezing injunction which was granted and carried on until beyond the consent order. And the law, paragraph 7 just deals with the question that, in general terms, that the injunction is in aid of execution upon the judgment herein. I mean, it doesn't say execution only in Cayman, but it's just in general terms, what I would say, it's a judged. Paragraph 1, it's a judgment, and paragraph 7, you can execute against the judgment. And well, I don't think we can get much more help from the wording of the judgment itself. Well, I'll close Owen and Rocket info in a moment. I just think paragraph 21, in case your lordship wants to look at it, deals with the indirect enforcement, I suppose, the trafficking of judgments point. And obviously, the court in British Columbia were alive to that, but said they approved the method by which, provided it's reciprocating territories, and the definition of original court, you could enforce in paragraph 13. Lord, I hesitate very quick to go on to the question of approaches to construction, but my lord, the only if I can just go on to the question of construction, Lord, York House, which is tab 17, just helpfully, Mr. Justice Zaccarelli sets out what I say are one of the relevant principles, and Lord, that's in paragraph 33. He sets out the principles on a landlord and tenant case to construe, and Lord, it deals with the question of paragraph 33 deals with Lord Regis' speech in Luke and Inland Revenue. I think we can jump that, but Lord, what the importance I say is that paragraph 35. The court was faced with a statutory provision which produced on a literal interpretation an outcome which Parliament could not have intended and for which no possible legislative purpose was identified. Nevertheless, the Court of Appeal refused to construe the provision otherwise than literally. And Lord Justice Stanley Burton, relying on Stock and Frank Jones, points out a court would only be justified in departing from the plain words of the statute, where it satisfies, one, that there was a clear and gross balance of anomaly, and Lord, I say there isn't. Parliament, legislative promoters and the draftsmen could not have envisaged such an anomaly, could not have been prepared to accept it in the interest of supervising legislative objective. Well, I say Learnfrey can't take that argument. The judge approached it on its own terms, the learned friend's original argument was on those terms, and there's been no appeal against paragraph 87 of the judgment. Going on, the anomaly can be obviated without detriment to such legislative objective. The language of the statute is susceptible to modification required to adopt an anomaly. Paragraph 36, this is the heart of my case. There was no ambiguity in the language, nor were the consequences of the application of the clear statutory language so absurd that one could see that Parliament may have made a drafting mistake. And the only relevance in Shanning is just that Lord Steyn, of course, says the tradition in this jurisdiction, in Law Authority 8, is not the conventional European approach, my Lord. If your Lordship has paragraph 8, tab 8, I'm so sorry, the authorities 1, the only part I think I need to, is Lord Steyn at paragraph 24, and there was the concern with the European directive and the regulation and the approach, of course, as to what the purpose was. Paragraph 24, there's an illuminating discussion across the correct approach to the construction of instruments of the European Community, such as the regulation question. The following general guide provided by Judge Fisher, and then the European approach, Lord, if we could jump to the break at sea. Cross points out that the four methods of interpretation, literal, historical, schematic, and of course purposive, my Lord. The first is the least important, and the last the most important. Cross makes two important comments on the doctrine of teleological purposive construction. First, in agreement with Benyon, Cross states that the British doctrine of purposive construction is more literalist than the European variety and permits restrained construction only in comparatively rare cases. Judges need to take account of the difference. And I would say, my Lord, the learned friend was on the territory when he was saying, well, if you're against me, you can always construe it, in a sense, to give effect to the purpose under the 33 Act and other policies identified. Well, that, in my submission, would be a strained construction. And the wording, as I said, to actually go beyond that, in my submission, the court could not depart from the clear word. Lord, finally on this submission, can I just say very quickly, my submission in answering some of the learned friend's points. The learned friend cannot succeed on his argument that the Cayman court had to exercise jurisdiction over the substance of the claim or had to adjudicate the substantive merits in the sense understood by the common law, which includes a default judgment, without, in my submission, contradicting or changing the statutory wording. And your Lordship will recall jurisdiction, for example, in section 9.2 is not defined. Commentators have pointed this out before, and so your Lordship recalls that in the 1920 Act, 9.2 points out no judgment shall be ordered to arrears on the session if the original court acted without jurisdiction. And it means, of course, jurisdiction as understood by the original court, here Cayman. Secondly, my Lord, because it appeared, and your Lordship, on my second submission I'll develop this very quickly, once you appear and voluntarily submit and take a part, then for most purposes you're taken to have accepted the jurisdiction of the court to give you bad news or good news. And Lord, I say, thirdly, for learned friend to succeed, and could I just ask your Lordship to note this without having to turn all this up, you would have to reverse, in my submission, the judge's detailed analysis and findings on these issues at paragraphs 105, 106, 107, 108, and 109. And, my Lord, to that extent, that's my answer on that. My Lord, I end as I started off by saying that, in fact, this judgment, issue on judgment trafficking, and judgment upon judgment in the sense that my learned friend is concerned, could quite easily have been dealt with on the approach the judge took on whether it was an abuse and so forth. And Lord, that's what I say on that. My learned friend refers to Benyon, but in fact, Lordship, 2 points. The Owen and Bracco reference is supplemental form. May I just make these points very quick so your Lordship has my submissions on them. The learned friend took you to Benyon, tab 4 of the supplementary bundle, and various paragraphs on them. Well, may I just make these submissions? I accept that Parliament, under the 1920 Act, plainly intended to supplement the common law and in large part followed it. But it's a statutory reciprocal scheme for registration. So I don't accept it has to be identical. There isn't a single common law case, or single case I think any of us will show that your Lordship has to construe the statute in accordance with the common law. One certainly can be guided by common law cases, but law, I say, supplements the common law. It certainly isn't the common law, so if you have an answer in the common law, that's the end of it. Lord, page 11 of Cross, referring to Owens and Bracco, may I just make the point that the editors quote the part of Owens and Bracco at page 489D, but they didn't, of course, deal with the part I rely on at 489F to G, which deals with how you get to the statutory construction to get to the answer that which civil law system applied. So you look at the words of the statute, and Lord, that's actually emphasised at page 18, if your Lordship, page 18, paragraph 25.5, where an act...
Sorry, where are we, Mr. Reza?
I'm so sorry, it's tab 4, the supplementary authorities.
We're in Benyon, yes.
That's right, yeah. We're in Benyon.
Page?
It's page 18, internal page 18 of tab 4.
Yes.
And Lord, it's paragraph 25.5, where an act uses a broad form of words, and of course, section 12 is a broad form of words. The courts often adopt a common law method, drawing on analogies with existing law to fill in the detail and arrive at a reasoned decision. It is important, however, not to lose sight of the primary task, which is to construe the words of the statute. So, Lord, I say we come back to that in any event. And the only other part of I would rely on, Lord, it's I don't think paragraph. Yes, it's you read pages 21 and 22 together. I think there's a quote from Society Cooperative Sid Metal and Titan, where Mr. Justice Woodbury on construction, and Lord points out that you don't lightly assume, but Lord, the answer to that in my submission is the words "any judgment." As the judge held, you can't escape the words "any judgment." And lastly, Lord, at page 22, where some change is clearly contemplated by an act, but the presumption is not entirely rebutted, the courts will seek to minimise the degree of legislative interference, for example, by referring to this act as regulating rather than replacing common law rule. The presumption, the significant presumption against changes to the common law is less than it once was, and so on and so forth. So all I just say is the presumption is not going to help you very much in this case. One comes back to legislative purpose and the words of the statute. Well, that's my submission 1. Well, my second submission, which I'll rattle through, is that if the common law position is relevant, what I submit is that the Cayman judgment and the respondent comply with the common law requirements. Lord, in my case, on the doctrine of obligation, and even on my learned friend's case, because I say, if I need to say it, that it was a competent court having jurisdiction over the substance of that claim. That claim was the claim brought in Cayman by the amended writ. Lord, Lordship sees that Cayman was already, the Cayman judge submissions were made on final, conclusive, re judicata and so forth. Lord, the doctrine of obligation, could I touch on this very quickly before I just take Lordship to one case? It's back to Dicey, and it's Authorities 20, Volume 2. Lord, So, Your Lordship, the first part of tab 20, hopefully, will be Rule 41. Your Lordship, I think.
Yes.
And Your Lordship, it's very simple. This is the a judgment of a court of a foreign country has no direct origination, but may be enforceable by claim or a defence. And my Lord, the common law route was that way, my Lord. And my Lord, very simply in 1407, so the expert evidence established on this point came and followed English law. My Lord, it's the middle paragraph. Your Lordship sees the familiar territory of Goddard and Gray and Blackburn in Russell and Smith. And it's the part which reads, we think the true principle on which judgments of foreign tribunals are enforced in England is that the judgments of a court of competent jurisdiction over the defendant imposes a duty or obligation on the defendant to pay the sum for which judgment is given, which the courts in this country are bound to enforce, so courts of Cayman, and consequently, anything which negatives that duty or forms a legal excuse for non-performing it is a defence to that action. And my Lord, so Your Lordship sees that in fact Note 17 specifically refers to Rule 48 on the question of enforcement, and the defences are, of course, no jurisdiction, fraud, public policy, natural justice, and my Lord, probably limitation as well. Because the rules of Cayman were very simple. If you want to bar the remedy, you have to take the point, as in England. And my Lord, of course, they didn't. They had the opportunity of doing so. And to that extent, my Lord, I would say that gives me a clear enforcement method of the means of judgment anticipated by Section 12. My Lord,
I think Mr. Onslow is making a different point. He's not saying that the Cayman Islands courts didn't have jurisdiction, because he's not allowed to make that point anymore. He's saying that at common law, before 1920, or indeed after 1920 at common law, you can't have an action on a judgment which is itself to enforce another judgment.
well,
And he says, well, there's no case about that, but it follows from principles in cases such as Nuvian and Freeman. I take it you haven't found any case on the point. Do you have any submission as to what the common law about that question is?
well, my Lord, the answer is tantalisingly suggested in Dicey in the third edition, which I think was the last edition Dicey gave, Lord, because he refers to, in part, the judgment of Lord Justice Lindley in the Nubian case before it went to the House of Lords. And Lord, the Dicey Old Edition is tab 21. And Lord, can I just show you the part which I relied on to say that it includes that sort of judgment as well, because there's commentary there, and as is applied. If you Lordship goes to page 444 of, this is the third edition, the last edition, Dicey himself edited. Your Lordship, seeing that Your Lordship's already been taken to Rule 112, which is on page 444, which was now modern Rule 48. And then foreign judgment is conclusive, any matter thereby adjudicated upon cannot be impeached, and so forth. And then, my Lord, what is then set out is actually the judgment of Lord Justice Lindley in Novian. If Your Lordship goes to page 445, Your Lordship sees the middle break, the principle on which an action can be brought on a foreign judgment is the rights the parties have already been investigated and determined by a competent tribunal, or that if such rights have not in fact investigated and determined, it is because the parties or one of them have made default and not availed themselves of the opportunities afforded them by the foreign tribunal. In an action on a foreign judgment not impeached for fraud, the original cause of action is not re-investigated if the judgment was pronounced by a competent tribunal having jurisdiction over the litigating parties. And then Goddard and Gray is again set out. And the part of Lord Justice Lindley's judgment in Novian, which is page 256, ends after the words, an expedient to enforce and enforce. And Lord, the editors simply say, this general principle, though stated in reference to a judgment in personam, applies to every kind of judgment. Now, Lord, I can't, what I say is if I need to, every sort of judgment applies in my case to the Cayman judgment. And, my Lord, to that extent, it's the sort of judgment anticipated by Section 12. My Lord, subject to that, my Lord, I haven't found a case which directly deals in this jurisdiction with judgment upon judgment upon judgment. Your Lordship saw the decision of the Court of Appeal of British Columbia on a statutory enforcement regime, which I rely on. But, my Lord...
but this passage seems to be talking about the judgment which determined the merits of the dispute, doesn't it?
Well, my Lord, say that, as Lord Justice Lindley says, if a party makes default...
Yes, but that's because they didn't appear and contest when they could have done, isn't it?
My Lord, those words appear as much, to a limited extent. You can't reinvestigate the merits in Cayman, but you can still defend them. And it was still open to the defendants that obviously were served with the acknowledgement service packs and all that sort of stuff, and they were served. And there's a regime in Cayman whereby they have the opportunity...
No, but, I mean, you have to read it in context, and the earlier part says, the principle on which an action can be brought on a foreign judgment is that the rights of the parties have been already investigated and determined by a competent tribunal. That looks as if it's talking about the court which resolved the underlying dispute on its merits. Or, if it didn't, that was because the defendant didn't defend what he was entitled to.
Lord, I would accept that would ordinarily apply to Singapore, of course, because that's the case where... But, my Lord, adopting those same words, if I sue on the basis of an obligation, which is the words that Lord Justice Lindley said, and I think endorsed by the House of Lords,
I see.
Because the right of action, the cause of action is different. It's the implied obligation to pay, the promise to pay created by the original
All
judgment.
I'm saying is I don't think that's actually what Lord Justice Lindley was referring to. Anyway,
well,
there we are.
my Lord, whether it was what he was referring to, I say that if I have to, I rely on the common law.
Yeah, you said common law. You can enter a judgment on a judgment. Isn't that what you're saying?
Yeah. Well, look,
What do you say about the academic commentators who say
well,
that?
Lord, what I say about the academic commentary is this: large parts of them rely on the analogous provisions of the 1933 Act as amended in 1982, the Brussels Convention, and of course, the European regulatory scheme whereby the civil law concept, judgment on judgment is not valid, has been adopted. So I say it's a different tradition in any event. But in any event, as I pointed out, none of the textbook writers except Dicey pointed out what happens to a judgment upon a judgment upon a judgment in a reciprocating territory where it seems to be of all fours in my case, it applies. The second point, I say it anyway, that is the sort of change. If you're going to say, well, Parliament says we depreciate that, then it's amending legislation law. I say that's what should happen. Not because the academics all say other provisions deal with it, other jurisdictions deal with it, because it's under the 33 Act as amended, it's under civil jurisdiction. Bracco, of course, was dealing with the position under the Convention. My Lord, classically, that's the sort of case where I say there should be amending legislation to deal with it, particularly when you've got a reciprocating network of friendly dominions that you trust, my Lord. If you're going to change...
Well, we're actually here, though, I think you're not addressing that. You're addressing the common law, aren't you? You've already addressed us on the 1920. Yeah. I mean, the only passage I would ask you to tell us whether you have any submissions on in this respect is that which is in Dicey at tab 20. Just want, I mean, not requiring you to make submissions, but I'd just like to know whether you have it, which is at page 721 of Dicey.
Yes, well,
so it's the paragraph which is sidelined.
Yes.
Paragraph 14.121. Now that doesn't depend on the 1933 Act, nor on any EU legislation or anything of that sort.
Lord, may I say it does, and my Lord, because I think I've dealt with this in my note.
But I'm really wanting to hear you on
Of course, my Lord. What I say is, if one goes back to 1421, the first point is the principle, executor sur executor novo, is a civil law principle. It's not a common law principle.
No,
so certainly, it's a principle that applies in civil law jurisdiction, France, Germany, and so forth. And of course, we know it's been adopted in the Convention. And we know that ultimately it was adopted in the 1933 Act because of the amendments to in Schedule 10, which came to Section 128. So the first thing, as I say, is that in fact it doesn't assist the question as to what the common law and or the 1920s Act applied. And Lord, may I say also that the argument that Dicey recites in 14.121 in fact depends on the amendments to the 1933 Act. If your Lordship goes to footnote 447, your Lordship sees that that is exactly what is...
But with respect, I don't actually think that is the basis of the argument. I mean, let's look at the text. Is there anything you want to say about the analysis in Dicey? That's all I want to know.
Well, my Lord, the analysis is this. In this, first of all, this isn't a case of enforcement or recognition. This is a case where there's been a judgment, a subsequent judgment. The second thing, my Lord, is the effect of the judgment is intended to be final and conclusive. And judgment was entered in after the judge was satisfied. It would be final and conclusive on common law concepts that applied in Cayman at the time. Your Lordship saw those outlined submissions. And, my Lord, the question of confusion, my Lord, I'm not sure that would arise here because Singapore, effectively, nothing else is going to happen in Singapore. We're concerned with the Cayman judgment. I can't see how, even if you had an argument about non-merger, or you could sue under the Singapore judgment, that's going to be going to confuse anyone. Dicey doesn't actually give any examples of confusion. In my submission, if there were examples of confusion that took place, they would be identified. And they haven't been. So
We have two different interest rates running. Judgment Act rates are different in Singapore and Cayman Islands, let's assume.
Yes, my Lord.
So which one does get enforced here if they're trying to enforce both here?
My Lord, in terms of answering any further comments on paragraph 14.121 in answer to Lord Justice Richard's question, well, may I just finish off my submissions on this? If your Lordship goes over the page, your Lordship sees that one of the examples given by Dicey, the third example, is because the confusion liable to result if both the judgment of the third country and if the foreign enforcement judgment were to be separately enforceable in England. Your Lordship sees in footnote 448 the Cortes case we've seen, which we learned a friend took you to this morning. And my Lord, Dicey sees that as an example of a judgment creditor may have to enforce his judgment in more than one jurisdiction, with more than one bite of the cherry point, I think, in paragraph 45 of Cortes. Lord, also, of course, Owen and Rocket Info, which is the case I took Lordships to, is cited there without any comment. So, to that extent, I suppose the confusion is avoided if you're adopting a statutory reciprocal enforcement scheme between reciprocating territories, as in Canada, as under the 1920 Act. That's all. And my Lord, the Morgan Stanley case is just the case that where a Hong Kong judge approached it in a different way and said that if it hadn't been for the amendments to the 1933 Act, judgment trafficking may very well have taken place. I don't know. Well, that's what he says there. I think that's speculation because I don't think anybody saw the notes to the Carr Working Committee recommendations when those comments were done, because, my Lord, I don't think they were published until 2005. I can't remember when, but they were difficult to get hold of. They certainly weren't published in normal textbooks. Well, they're my comments on paragraph 14.121, Lord. And what I just say is that could I say that the Cayman Island judgment did satisfy the common law test? My Lord, I say they're elastic. I accept there's no direct case on it. First of all, because it pursued the doctrine of obligation as identified by Lord Collins in Rubin and Eurofinance since Lord Lindley. that was the theoretical basis of the obligation. It's a separate obligation created by the Singapore judgment. So I was entitled to follow that course. And then it was a judgment as envisaged by Section 12, because it would have been a common law judgment. But in any event, I say the reason why I can rely on the common law is because it satisfies all the tests identified by Lord Herschel and Lord Watson in Nubian and Freeman law, because Cayman certainly, and I say also Cayman, Singapore certainly, and also Cayman, because first of all, the appellant had made default and not availed itself of the opportunity to defend in Cayman. Secondly, it waived or failed to have any rights to contest the merits of that new claim, again per Lord Herschel. And it also had an opportunity, even though they were restricted, there were still defences, of submitting for decision all the pleas they wished to put forward in defence. And they didn't. And so I say the common law test has been satisfied. Lord, I don't know if it helps your Lordship to make the point that the implied contract cause of action is a separate cause of action, which in England is treated as action as of right, and treated as a separate cause of action which the party is entitled to sue on. It's a different scenario because it's England within England, but it acknowledges the fact it's a new cause of action. My Lord, perhaps I could just look at it briefly. Authorities 9, Volume 1, Tab 9. Well, this is Bennett, which the judge did have submissions on, and she made a point about the reason for why the second enforcement action took place. And Your Lordship sees decision of Lord Justice Mummery, Scott Baker, and Mr. Justice Lawrence Collins, as he then was. In paragraph 4, I think, picks up the facts as to the bank, Your Lordship sees the head note, brought a second action based on the original judgment against the debtor, and the debtor tried to set aside that default judgment. And Your Lordship, if Your Lordship sees paragraph 4, Lord Justice Mummery's judgment, the general principles regarding actions on an existing judgment as an abuse of process were stated by Lord Justice Leggett in E.D. and F. Man Sugar. And Lord sees there that it's not an abuse of process if there's a proper reason for suing on the judgment. And as Your Lordship saw from the chronology, we sued in Cayman because we thought there was a means of enforcing the Singapore judgment. And Your Lordship sees the important words for Your Lordships, in the middle of paragraph 4, it would, in my judgment, be for a defendant to show that a second action did constitute an abuse of process. The primary obligation is not that of a plaintiff to justify the bringing of further proceedings, because in the event of abuse, the court may intervene and refrain from giving judgment in the second action. It cannot be said that the second action proceeds without judicial scrutiny, even if the second action is a matter of right and not discretion. And then, my Lord, last break, the authorities drawn to attention has shown that the bringing of a second action to be a matter of right. And in my judgment, that is what it is. And my Lord, that paragraph 18 was the concluding remarks on an English action on an action. Paragraph 18, actions on domestic judgments are certainly unusual, however clear from section 24 of the 80 Act and principled by Lord Justice Leggett and other authorities. The 1995 judgment created a new debt. The banker's judgment creditor was entitled to proceedings based on the judgment debt independently, and then goes on to say it wasn't abuse. Lord, that has been followed. My Lord, in Authorities 14, Lordship sees decision of Mr. Justice Tier, Lord Lordship sees, just to say Lordship has that. In this case, they started the second proceedings against the debtor, because they said there were difficulties in enforcement overseas. And my Lord, it's paragraph 8 makes the point that claimants are in principle entitled to seek a judgment against Mr. Al-Bada upon the judgment in the first action, however surprising that may seem. The juridical basis of the second action has long been explained as being an implied contract to honour the judgment in the first action. Then Your Lordship sees Grant and Eastern, F. Man Sugar. And then makes the point in paragraph 9 that the reason, whether it's an abuse, depends on the reasons for it, and I come back to the point I made. We found a fund, the Wang Fund, which we wanted to enforce in Cayman, and then it's always subject to judicial control, and the law, and then paragraph 11, the reasons why it was necessary for the following proceedings. So what I say is that civil law principles, I am entitled to sue on the implied contract, the new cause of action in Cayman, and that's the alternative route. That's the doctrinal obligation, and I say I'm compliant with it. Well, I don't think I would say anything further on submission 2. What I do say, I want to go very quickly to, very quickly indeed, my Lord, to submission 3. I say, first of all, the purpose of construction, if you do have to have that, regard to the common law, Parliament never intended to exclude a judgment upon judgment or exclude judgment laundering. And, my Lord, the one part of, could I just take one part of sum there, my Lord, because it's the part I think which may help Your Lordship in terms of seeing the parliamentary objective. Your Lordship goes to tab 26. Lord, I made the wrong. I didn't think the Lordship had taken to this paragraph. Paragraph 32, and the most important paragraph is paragraph 33.
So hold on, we're at tab 26.
26, Lord.
26. Well, we'll just get there.
Lord, this is the summary report.
Okay. So where do you want us to go? Sorry.
Paragraph 32, Lord. It's page
32.
10. And Lord, paragraph 32 sets out the differences, the geographical problems, differences in procedures between courts within the empire, different circumstances, and so forth. And that was the problem, and it was a problem recognised by the committee. And Lord, the heart of the parliamentary objectives are set out in paragraph 33. So, my Lord, the first thing is, for the mere formal verification of the judgment to be enforced, we recommend the substitution of an order of the court or a judge to be granted as a matter of discretion. So, not like the 33 Act as amended of the Convention, so an automatic judgment, but as Your Lordship points out, judicial discretion, only where the court is satisfied enforcing judgment with which was pronounced is just and convenient, and then that addresses some of the difficulties and points out the fact that the remedy may be found in judicial experience and caution, not intended that leave to enforce judgment should be given as a matter of course, and nor, on the other hand, is it intended that the procedure be recognised by the forum which it is issued, nor, on the other hand, is it intended that the application to enforce an examination of the merits and the cause be obligatory. Where the defendant's voluntary appear, there can be no question that he ought to satisfy the judgment. And then, my Lord, words I rely on about an inch from the end, the sentence, a defendant should always be safeguarded by a proper opportunity of showing cause before execution proceeds so far as the final alienation of his property. So, my Lord, there's 3 parliamentary objectives identified there. First of all...
Wait a minute, they're not parliamentary objectives, they're
I'm so sorry.
aims at which the committee's report
Yes.
is directed.
I apologise. That is, but what was intended, and the recommendations put forward was that where a defendant has voluntarily appeared, there can be no question he ought to satisfy the judgment. And in this case, in Singapore and in Cayman, because we eventually have the consent order and we have the adjournment, I want to look at the things and I want to agree to the order, they have voluntarily appeared. And so on that basis, the approach would be the sort of judgment that should be enforced. The second recommendation, which eventually became part of the parliamentary objective, was that there should be a discretionary order, and that's very important. It's important. It's not just the factors in 9.2, the 5 factors are there, but it was also all the circumstances, also after the court satisfied that it's just. And that exercise, of course, par excellence, is the exercise that the judge followed. And thirdly, that the defendant should be safeguarded of proper opportunity of showing cause before execution. Well, that's also the exercise the judge undertook towards the latter part of the judgment when she looked at the writ of control and said, well, I've got to look at this separately as well, which she did. And Lord, in my submission, that is as much part of the construction of what was intended by section 9 and 12 as part of the parliamentary scheme. And there's a reason why your lordships can give effect to a purposive construction of the judgment of section 12. Lord, I've made this point. The second part of submission 3 is that it's the sort of amendment adopting the civil law procedure, civil law rules that has to be appropriately dealt with by way of parliamentary legislation. Lord, there's only one part of the working committee reports. They haven't been produced very easily. Lord, this is tab 28, and tab 28 has the Carr working paper recommendations as to why there were amendments to the 1933 Act,
Sorry,
as
what
well
are
as
we
all
looking
the
at here?
provisions of the 1922 Act. And there's only one paragraph which I think is...
Sorry, it's very difficult to read the manuscript notes at the top of the first page. What exactly is this document?
What these documents are
This is precursor to the 1982
two acts, that's right.
Yes, I see.
It is the files, photographs of each of the contents of the 6 files of the working committee advising the Lord Chancellor before the 1982 Act was passed on various aspects of the Civil Jurisdiction and Judgment Bill. And if your ladyship looks, for example, at tab 28, the first entry should be a file, if it's legible, LCO 64-4.
Yeah.
And there were 5 files which contained material which was relevant to the reasons why the 33 Act was amended, section 1.2a, which the friend took you to this morning.
Were these ever published?
These weren't published, but they were in the Public Records Office. But they were certainly referred to. If your ladyship goes to tab 29, there's Hansard, and that's the second reading of Lord Helsham. And if your ladyship sees Civil Jurisdiction Judgment Bill, page 1, sets out the intended passing of the 1982 Act. And if your ladyship looks at the bottom marked passage, in preparing the contents of the bill, the government has benefited from the advice of a working party.
Sorry, where are you again? I've lost.
Bottom of page 1 of tab 29, my lord.
Bottom page.
Which is the Hansard.
Sorry, just
second
sorry.
reading.
Page 29.
Yes.
Sorry. So what are
I
we
don't know
looking
if
at?
that's got-
Sorry, now, please just let's stop. So we're now looking at the House of Lords debate on the Civil Jurisdiction and Judgments Bill.
Yes.
Now, why are you taking us
To
to
answer
parliamentary
my lady's
debate?
question as
Yes.
to why the previous notes are of any relevance at all.
But the question is, are they admissible to construe the statute? And if they aren't published, I'm struggling to see how they're admissible. I mean, there's a decision of Mr. Justice Sales then was saying that notes on clauses are not admissible to construe a statute, and I'm wondering how these documents are admissible.
Well, the only relevance I rely on is to show that when the amendment to the section 1.2a of the 1933 Act came about, it was for not reasons to follow the common law, it was for other reasons.
Yeah. Was there not some other material available on this? But I may be wrong that there wasn't. Didn't Didn't Lord Justice Carr or someone chair a committee that looked at this? Wasn't there something, as my lady has said, something that was published, or is this the sole paper trail we've got about this?
Well, there's two. First of all, there's the publishing of the Hansard.
Well, I know, but
Second reading.
was there any? I just at the back of my mind, but I think I've got this wrong. Maybe that Lord Justice Carr chaired some group that looked at this.
Well, he certainly advised on other
did.
aspects of the.
Well, did he not advise on this aspect?
He
Or
did.
not?
That was the purpose. He advised on this aspect.
But that's not in here, is it? Is that in a published report of
That
this committee?
that part has been published. On
Well,
the 82.
won't that give us as good an answer as anything, or not?
No, I couldn't find anything in there at all.
Oh, I see. There's nothing in there as to why they have.
The only
I thought
thing.
there was, but I may be wrong about that.
The only things in these working papers on expression of admissibility is that the final Schedule 10, which eventually led to Section 1.2a being amended, there are reasons explained as to why the amendments to the Act or the recommendations as to why they should take effect, and they were eventually amended in those terms. And Lord, may I deal with that looking at the material first, so, as to whether it is admissible. If it's not, I'm not going to go any further. If your Lordship
Oh, I see. Yes,
my
he's,
notes-
the working party, Lord Justice Carr. Yes, so I was.
It's just there.
It's just there.
Yeah.
So his working party looked, didn't it, as to whether there was some amendment needed to conform
Yeah,
to the EU legislation.
that's right.
Isn't that right?
Yeah.
And was his working party's report published?
It was
anyone
just
informed?
recommendations in the course of various committee meetings. I don't think there was ever.
There wasn't a report.
There wasn't
It's
a-
not like the Greer or
no,
Sumner
no,
report.
no, there wasn't the report. I couldn't find
No.
it.
Okay.
There was a Scottish report, which
There
was
was a Scottish
published, so it would be surprising if the English one wasn't.
That hasn't been brought, Your Lordship. I think it's 3 volumes.
I'm not
But
saying
it was on other aspects. I don't think it covered any of this at all. But Lord, may I just deal with the point? And if it's not admissible, I'm not going to push it, and I'm just going to deal with my last.
But you're going to tell us why that amendment was made.
Yeah, I'm just going to tell you.
Why was that amendment?
My submission is that the amendment was made because, Lord, and I hope to make this on the last part of the report, although it's touched on early parts. First of all, it was not to follow the common law. That's the first thing. The second reason it was amended were because Parliament was worried that the 1982 Act and the 1933 Act, unless it was amended, would be in conflict with European Union law and might be excluded by the Brussels Convention. And the last reason it was amended was because to aid further negotiations with other intended contracting parties, such as Canada. There was a great deal of negotiation going on. And that's the reason. And it's set out in one passage, Lord, in the last Working Party report. And, Lord, it is report L60648, which is the Working Party notes. And it's,
So we're back in, where are we? Back in tab 28, are we?
that's right, it's the back end of tab 28, right towards the end. And if your Lordship sees notes on clauses Schedule 10, Schedule 10, this is the final form of Schedule 10 because it was amended throughout a period of 1.5 years. And then we get to Schedule 10. Schedule 10 contains amendments to the 1930 Act, the most important of which is to enable the Act to be applied to judgments of other courts and tribunals, as well as judgments of superior courts. So it included county courts, well, there were no superior courts because the money amounts were then important. And then you see that that's practical importance. Now that the pecuniary limits on the jurisdiction of the inferior courts are so much higher and disputes with international elements are much more frequent, this reasoning no longer applies. The 68 Convention applies to all judgments of all courts and tribunals. And this presents a difficulty in concluding the conventions on recognition and enforcement with such countries, including Canada, with whom negotiations for convention are in progress. And then, my Lord, we go over the page, which comments on the amendments. I don't think I need to look at that because it's eventually going to Parliament. But if your Lordship goes over the page to page 3, I hope that that's come out. And, my Lord, it's the paragraph which says very simply, judgments are excluded from enforcement under the Act, that is, when passed, if they were originally given in a third country but have been made enforceable for any purposes in the country to which the 1933 Act is extended, whether by proceedings similar to the common law action in the United Kingdom or by registration under statutes comparable to the 1920 and 1933 Acts, new section 12A, B and C. So they were abolishing the common law right of action under the 33 Act. They had already abolished recognition, they were just abolishing the right under the 33 Act, but not under the 1922 Act. Thus, if a convention were to be concluded with Canada, it could not cover judgments emanating from the United States, which is a non-reciprocating territory, my lord, which might be given on grounds of jurisdiction which would not be recognised in the European Kingdom, or other conditions which would not be acceptable in the United Kingdom. The position of the 33 Act is presently uncertain, but it is thought that under the 1968 Convention, indirect enforcement of judgments manner, e.g. judgment given in Switzerland, is implicitly excluded. So, my lord, as I said, that in my submission is the reason. It wasn't to follow the common law. It's because of negotiations, because they thought it might be in conflict with the convention unless they amended it. And, my lord, they were the reasons. So, my lord, that's why I say I'm not sure this is going to help your lordships in construing the 1920s Act. I say you can't go down that path anyway, but for what it's worth, it wasn't to reflect the existing position of the common law. There were specific reasons why the 1933 Act was going to be amended.
One might infer that anyway from the legislative context of the 1982 Act without looking at the notes on clauses, because one of the things that it does is to bring the Brussels Convention implemented in English law, and there's this, anyway.
Well,
Yes.
I would certainly invite your ladyship to infer that because as I said, that there has to be a reason why they amended the 33 Act, but they didn't amend the 1920 Act. There must have been a reason. It wasn't just an oversight.
I mean, Root, what you're saying probably is it wasn't a sudden afterthought. Oh my goodness, we got the common law wrong.
Yes.
In the 1933 Act.
That's precisely the point. My lord, can I just, my fourth submission, I look at the time with horror, I'm so sorry, my lord. I don't know if Lordship wants to carry on hearing this.
I mean, just you've got. I think we've dealt with your first three submissions.
That's right. Well,
and then you had some point about the. Are we moving on to your consent order point?
I'm going on to consent order.
But sorry to interrupt you, but we have only one issue before us, and it's a matter of statutory construction, and that is whether the 1920 Act permits registration of a judgment on a judgment. And I can't, for my part, see how reference to the consent order in this particular case is going to assist in that, resolving that issue.
It's a respondent's notice, my lord. It's a point I say it's an additional part, separate part to uphold the order. And if your lordship doesn't want to hear it or doesn't think they need to hear it, then, my lord, that's so.
Well, I don't see how it goes to the only issue that's before us, does it? I mean, what are you saying? That even if Mr. Onslow is right in his appeal, you've got some other basis for. I mean, I just don't understand it, actually.
Well, Lord,
I mean, either the court has jurisdiction. I mean, Mr. Onslow's submission is that the court has no jurisdiction under the 1920 Act to enforce a judgment on a judgment. And if he's right about that, well, that's the end of it, isn't it?
well, Lord, that's why. Well, on that view, yes, my lord, that would.
Well, I mean, I don't understand what other
Well,
view there can be, but
the point is it's very simply put, my lord, in my respondent's notice, and it is that. Lord, can I just take your lordship? If your lordship's not.
very quickly.
Yes, of course. Well, it's tab 3, and the point is very simple. It's page 26, and it just goes to the consent order, and it's paragraph 2, Roman 1, that the judge should have held, submission's word made to her, that in any event that the judgment should be upheld because of the effect of the consent orders. I mean, Lord, it's spelt out.
But surely 1, A, B, and C is. I mean, Mr. Onslow isn't contending to the contrary of any of those points. It's not open to him to do so. This is a point of English law. I'm afraid I just don't understand the point, Mr. Reza, you're trying to make.
The point is, my Lord, well, is that if your Lordship says that there couldn't be a registered Cayman judgment because, for example...
Sorry, not a registered... The question is whether there can be an English judgment.
That's right, English registration.
Of the Cayman judgment.
Because
yes.
the Cayman judgment didn't deal with the common law test in the appropriate way.
No, that's not... Sorry, there's nothing to do with it. That's not a point that is raised before us, nor is it open to Mr. Onslow to raise it before us, and he's not done so. It's purely a question of the jurisdiction of the court under Section 9 of the 1920 Act. So he has to assume that everything was properly done in Cayman because he's been refused permission to appeal on those aspects of the case. See how your respondent's notice can get round the point that he does raise on this appeal and for which he has permission.
Well, my Lord, the submission was simply that the consent order constitutes a consensual acceptance of the jurisdiction to deal with the substantive merits if necessary in Cayman. That's what the point.
Right, well, thank you for that. Well, thank you. I'll just say, are there any questions? Any questions? No, thank you, Mr. Reza. Yes, Mr. Ross.
I've got a few points in reply. First, we now have proper copies of we have copies of the 1933 Act, which I'm going to hand up
Thank you
in
very much.
3 chunks, and also we've added the complete series of extracts from Patchett as well.
I'm grateful.
So there are 3
Thank
of
you
those.
very much indeed.
To go behind tabs 2, that'll be Authorities Bundle 1, and tab 24 in Authorities Bundle 2. We do, in fact, also have better copies of the materials that Mr. Reza refers to, but unless the court wishes to see those, I wasn't going to hand them up because he doesn't seem to be relying on anything that is presently illegible. But I'm happy to provide them and can do so after the hearing is concluded. The third point is that we are looking into the question of the year of the extracts from Benyon. Certainly the extracts that we provided, which are the ones on the common law test, the use of the common law, and on looking at later legislation, they certainly came from the 2019 edition. The other extract came from a friend, and if it's not the 2019 edition, it'll be the 6th, and we'll make sure you get the up-to-date version. In terms of points of substance, just working backwards, we can see that the last of those working paper documents that you were taking to behind tab 28, 2 pages from the end of tab 28, may shed some light on what was happening because of the last sentence. The position under the 1933 Act is presently uncertain, but it is thought that under the 1968 Convention, the indirect enforcement of judgments in this manner, e.g. a judgment given in Switzerland and granted enforcement in France, is implicitly excluded. The point being that it's uncertain. They seem to be acknowledging that the issue that we're grappling with today, at any rate so far as the 1933 Act is concerned, is undecided, and no one quite knows the answer. Now, if the answer is as we say it to be, well, that wouldn't create any problem or any inconsistency with the European legislation, with the European regime. If it were to be, as Mr. Reza says it is, or at any rate under the 1933 Act, applying or adopting or recognising the common law, it were to be the position that a judgment on a judgment is within that Act, then there would be an inconsistency, so it would appear, with the Brussels Convention regime and so on. So it looks to us, and this is just me looking at this this afternoon and thinking about it further, it looks to me as if this was an abundance of caution exercise. That's the best I can do, and this is the closest one comes, and I'm grateful to Mr. Reza for finding this. This is certainly the closest one comes to what probably they had been advised by Lord Justice Carr's committee, but we don't know. We will have another look, but we understand that there isn't a working party report from Lord Justice Carr's committee, and Mr. Reza is right when he says we can't find that there isn't anything that will actually help on this point. We can look at the Scottish report and see if there's anything there.
Yeah, okay.
The second point I wanted to deal with is the Owen and Rocket Info case, because in fact, when one looks at that, at any rate in our submission, it substantially supports our case in this appeal. It's behind divider 15 in the first bundle of authorities. And the point I'm about to make goes to a basic point that Mr. Reza made to your lordships. And he says, well, the purpose of the 1920 Act was to promote and promote reciprocity, to reflect. He read out the preamble, and I haven't got it written down. But at any rate, it was concerned with allowing for and promoting the recognition of enforcement of judgments with reciprocating states. Now the ultimate problem with the claimant's position in the Owen and Rocket Info case was not, so it would appear, with the meaning of the phrase court. It was with the meaning of the word judgment. Because if one goes to page 377, having dealt with the question of what original court might mean, and frankly, if we had to say that the decision in the Gersberger and Kress decision was wrong, or at any rate would be regarded as wrong here on our language, but put that to one side, it's the judgment aspect I want to focus on. The court says, in my view, there are several other provisions of Part 2 that reinforce the conclusion that the term judgment does not include a judgment registered or entered on the basis of a judgment granted by a court of another jurisdiction pursuant to legislation for the reciprocal enforcement of judgments or the full faith and credit doctrine. And then they go on to point out that in paragraph, they go on first in paragraph 19 to point out that the relevant provision in the British Columbia rules refers to a writ of summons or statement of claim, and that's a reference to an originating process, such as the complaint issued by the Nevada court and served on the respondent. There was no originating process in California, point of distinction from this case, obviously, because there was some form of originating process where the judgment was entered upon the filing of a sworn statement containing information about the sister state judgment. What the court is doing here in paragraph 19, paragraph 20, as we'll see, is doing what I was inviting the court to do, which is to pick up clues from the text of the statute we're dealing with for the purpose of deciding which side of the line the statute falls. But then 20, remainder of these provisions are contained in subsection 6, which sets out the a judgment cannot be registered in British Columbia. 3 of these circumstances relate to the kind of action commenced in Nevada, but not to the California process. Subparagraph A2 refers to the original court having acted without authority to adjudicate concerning the cause of action or subject matter that resulted in the judgment. And I say, likewise, when you see references to exclusive jurisdictions and clauses and the like in the 1933 Act, and we say the same approach must be taken to the 1920 Act, that's a strong indication that they're concerned with the original judgment as I've suggested it is. And then a number of other points are made in paragraph 20. But then there's this, and this is the crux of it. Paragraph 21. My interpretation of the term judgment is consistent with the purpose of the legislation as contained in sections 29.1 and 37.1. To allow the appellant's judgment to be registered in British Columbia would have the effect of permitting the registration of a judgment granted by a court of a non-reciprocating jurisdiction, contrary to the intent of sections 29 and 37. In my view, the legislature did not provide for registration in British Columbia of a judgment granted by a court of another jurisdiction by an indirect method, when it is not permitted to be done directly. Otherwise, when the Lieutenant Governor in Council declared a state to be a reciprocating state, it would have the effect of declaring all of the jurisdictions that are reciprocal to that jurisdiction to also be states reciprocal to British Columbia for the purpose of registering judgments. In the case of declaring California to be a reciprocating state, the Lieutenant Governor in Council would effectively be declaring all other states of the United States of America to be reciprocating states, because California permits the entry of sister state judgments issued by a court of any of the states of the United States. Now, that was an unavoidable consequence of allowing in a California judgment. And I can't say that it's an unavoidable, that on Mr. Reza's construction, it is an unavoidable consequence of allowing the registration of a Cayman Island judgment on a judgment, that it opens up automatically, if you like, the whole world to enforcement of a judgment from an original court outside the scope of the 1920 Act. But what I do say, and we touched on this point this morning, what I do say is it does have equivalent effect. It does mean that any judgment from anywhere in the world that is capable of being enforced at common law in Cayman can be brought within the scope, if Mr. Reza is right, can be brought within the scope of the 1920 Act. And we submit that cannot be what Parliament intended, essentially for the reason that Mr. Reza gave, that what it's concerned with is the enforcement and recognition of judgments from reciprocating countries, and no more than that. So we do say that the Owen and Rocket Info case, in fact, when one looks at what actually happened in it, supports our position. The only other point, subject to any questions that your lordships and your ladyship may have for me, I do apologise. I keep muddling my address to the court. I should say the court may have. It's the case of Yearwood you were taken to, and we see what is said. We'd better turn it up again. It's in the second authorities bundle, behind divider 18, in my second authorities bundle. And it's what we see at paragraph 18, and the general comment that the board does not consider that it can derive much assistance in determining what was intended to come within the definition of the term judgment in the Act from older common law cases such as Nuvian and Freeman. And we make a number of points about that. The first is that Yearwood was not concerned with the question of judgment on a judgment, whether within the Antigua and Barbuda rules or within the English Act. The second point is perhaps the obvious one, that it's the Privy Council and it's obiter, it's not strictly binding on this court. Even if it were to concern the English legislation, it doesn't. It concerns only the Antigua and Barbuda legislation. That may be in similar terms, but strictly speaking, it's not binding for two reasons on this court. But the third point is that there's nothing in the judgment to indicate that the issue, even so far as the Antigua and Barbuda rules were concerned, was given the type of treatment and analysis and examination that it has received in this court today, and in the quite extensive written submissions that the court has received. In particular, it's not evident, at any rate from the judgment, that the relevant, well, what we say are the relevant passages from Dicey, Professor Briggs, Professor Smart, and so on, were cited to the court. And the fourth point is the court point out that what they're concerned with, in fact, in their case, is an order made in proceedings brought under the Matrimonial Causes Act 1973, and for that reason, they don't think that the common law has much to say on the matter they're dealing with. This is particularly so, they say, when the order with which the board is concerned is an order made in proceedings brought under the Matrimonial Causes Act 1973, and we don't have that difficulty here. And finally, and with due respect, we say it is evident from the cases we've looked at and all those authorities and textbooks we looked at, and indeed from Benyon itself, that it is right to construe the 1920 Act, and I'm bound to say would have been right, I say, as I repeat, with all due respect, would have been right to construe the Antigua and Barbuda Act, assuming that it followed the English position. It would have been right to construe those provisions by reference to the common law. So that, with all due respect, if this is intended as a general statement that you shouldn't be construing those types of provisions by reference to the common law and what it previously provided and the way it's been applied, developed and adapted for these statutes, both the 1920 Act and the 1933 Act, I'd be bound to say that the Privy Council were in error.
Well, maybe the most significant point of those, if I may say so, is the first.
Indeed.
Yes.
So, unless I can help the court any further with...
No? Thank you.
Thank you very much, Mr. Lord. Thank you. Well, the court will reserve its judgments and they'll be circulated in draft in the usual way for your typo and similar minor corrections, not of course for any re-argument. We'd be grateful if you could agree an order, but if you can't, we'll have written submissions on any differences and we'll resolve them on the papers. And the judgments will be handed down in the usual way now, which is remotely, so there won't be even a further formal hearing. Thank you all very much.
All right.